Aloha mai kako and good morning. This is the September 24th, 2020 Land Use Commission meeting, which is being held using interactive conference technology, linking video conference participants and other interested individuals of the public via the Zoom internet conferencing program in order to comply with state and county operational directives during the COVID-19 pandemic. Members of the public are viewing the meeting via the Zoom webinar platform. For all meeting participants, I would like to stress to everyone the importance of speaking slowly, clearly, and directly into your microphone. And that before speaking, you please state your name and identify yourself for the record. Also, please be aware that all meeting participants are being recorded on the digital record of this Zoom meeting. Your continued participation is your implied consent to be part of this event. If you do not wish to be part of the public record, you may exit this meeting now. The Zoom conferencing technology allows the parties and each participating commissioner individual remote access to the meeting proceedings via our own personal digital devices. Please note that due to matters entirely outside of our control, occasional disruptions to connectivity may occur for one or more members of the meeting at any given time. If such disruptions occur, please let us know, and please be patient with us as we try to restore audio and visual signals to effectively conduct our business during the pandemic. My name is Jonathan Likeke Scheuer, and I currently serve as the Land Use Commission Chair. Along with me, Commissioners Axon, Chang, Okuda, and Wong, our LUC Executive Officer Daniel Ordinker, LUC Chief Planner Scott Derrickson, Chief Clerk Riley Hakoda, our Deputy Attorney General Cindy, oh, you are not Cindy Young, Linda Chow. You switched roles or bodies. I'm going to just say you switched assignments. Linda Chow are on Oahu along with our court reporter, Jean McManus. Commissioner Cabral is on Hawaii Island. Commissioner Ohigashi is on Maui, and Commissioner Giovanni is on Kauai. We currently have 8 seated commissioners of a possible 9, and all are in attendance today. Our next order of business is the Office of Planning's motion for reconsideration of the order of the Fourth Amendment to State Special Permit SP 97390 for the proposed Central Maui Landfill Facilities Project at TMK 23-8-003, Lot 19, a portion thereof, and Lot 20 at Pu'unene, Maui, Hawaii. Will the parties for docket number SP 97390 please identify yourselves for the record. You might need to unmute yourself.
Should I go first? Deputy Attorney General Dawn Apuna on behalf of the Office of Planning.
Good morning, Ms. Apuna.
Michael Hopper, Deputy Corporation Counsel representing the Maui County Department of Planning. With me are Deputy Director Jordan Hart and Planner Kurt Wollenhaupt.
Good morning, Mr. Hopper. Thank you. Let me update the record. On August 13th, 2020, the Commission mailed its decision and order in this matter. On August 28th, 2020, the Commission received the Office of Planning's motion for reconsideration. On September 14th, the Commission mailed the September 23rd and 24th, 2020 notice of agenda to the parties and to our statewide Oahu and Maui regular and email mailing lists. On September 17th, 2020, the Commission received the Department of Environmental Management County of Maui's joinder to OP's motion for reconsideration. Let me go over our procedures for today now. I will first recognize any written testimony that has been submitted on this matter. I will then call for anybody wishing to provide oral testimony on this docket. If there are any people, I will admit them in turn into the meeting room, swear them in, give them 3 minutes to provide testimony, and following their testimony, they will be available for questions by the parties and the commissioners. After all registered testifiers complete their testimony and all other testifiers complete their testimony, we will proceed with OP presenting its case. After OP has completed its presentation, they will be followed by the County of Maui. From time to time, approximately 10 minutes every hour, I will be calling for short breaks. Are there any questions on our procedures for today? Seeing none. Oh,
No, Mr. Chair, but I think County of Maui Department of Environmental Management is also present. I'm not sure if they identified themselves as the applicant. But I just wanted to.
okay.
I think they're there.
Okay, I waited for an intro and didn't hear it, but please identify yourselves at this time.
Thank you. My apologies for that. Rochelle Thompson for the County of Maui, and with me I have Eric Nakagawa. He's the Director of Environmental Management, and Elaine Baker is a Civil Engineer 4 with Department of Environmental Management.
Thank you very much. Commissioner Ohigashi.
Just to be clear, I just wanted, because Mr. Hopper and I'm not sure, Ms. Baker, that's who it is? Anyway, there are two representatives from the County of Maui. And when you mentioned that the County of Maui goes next, I was just wondering which one of them would be the lead counsel in this matter so that we have only one.
Mr. Hopper.
Well, I'd want to note that I think we represent separate parties. We represent the Department of Planning, who's generally an automatic party. And as EM isn't the actual applicant in this case, they would represent the Department of Environmental Management as the applicant. I think we did the last time, so that's what our plan was.
Mr. Ordenker or Ms. Chow, my inclination is to then allow Mr. Hopper followed by Environmental Management to comment on OP's motion.
I believe that would be appropriate.
Okay. Thank you. Mr. Derrickson or Mr. Hakoda, has anybody provided written testimony on this matter?
Chair, this is Riley Hakoda. I did not receive any public testimony.
Okay. Thank you. There are 6 attendees in the attendee section of this meeting. If any of you wish to provide public testimony in this matter, please use the raise hand function on Zoom and raise your hand at this time. If you want to give public testimony, if you do, I will let you in. Seeing none, there is no public testimony on this matter. OP, you may proceed with the presentation of your argument.
Thank you, Chair. It's kind of nice to go first for once.
We're always meaner to the people who go first, so don't treasure it too much.
No, I understand that. So thank you, Chair and Commissioners. We appreciate this opportunity to present this motion for reconsideration. And thank you to the Maui County Departments of Environmental Management, Planning, and Corporation Council for their joiners to our motion. 2 issues are before you. First, Condition 23 of the Central Maui Landfill Special Permit Decision and Order requires the county to commence the district boundary amendment process for the 22 acres of IAL land. OP thought that the DBA was for the entire 95.659 acres. The hearing transcripts are not clear or conclusive as to the appropriate acreage of the SP area. We ask that the Commission provide the intended acreage or area for the required DBA. It's either the 22 acres of IAL, the entire 95.659 acre SP area, or some other acreage. The second issue is whether a DBA to urban is a more appropriate permitting vehicle than a special permit for a landfill in the agricultural district. OP understands that in deciding landfill special permits, the commissioners are put in a tough spot, having to weigh among competing factors of an essential public service, community interests, evolving waste management technologies and policies, and sometimes unfulfilled commitments. While a special permit may not be a perfect process, OP believes it is the appropriate vehicle to permit a landfill in the agricultural district for several reasons. First, a landfill is an unusual and reasonable use. A landfill generally should meet the 5 guidelines of Hawaii Administrative Rules, Section 1515-95C as follows. Unless a landfill is displacing active agriculture or endangering land with a high capacity for intensive cultivation, it is unlikely to be contrary to the objectives of the land use law. and the eventual return of the use to agriculture following the temporary landfill use would be consistent with the agricultural preservation and conservation objectives sought to be accomplished by Chapter 205. Certainly, there is the potential for a landfill to adversely affect surrounding property, but proper mitigation measures could lessen a landfill's adverse effects on surrounding properties. As an essential public service, a landfill would not unreasonably burden public agencies. Since the district boundaries and rules were established, landfills have become a more accepted and regulated use of waste disposal. And depending on the proposed landfill site, which is case and fact specific, the site could be unsuited for the uses permitted within the agricultural district. While these are merely guidelines that are not strictly required to be satisfied, none of the 5 guidelines are necessarily unattainable that a landfill cannot be considered an unusual and reasonable use, and therefore can and should be considered under a special permit. On the other hand, a district boundary amendment is the proper permitting mechanism when a use simply does not fit in its current use district of either conservation, agricultural, rural, or urban, and is better suited in one of the other 3 districts. A DBA is not proper because a landfill in the agricultural district is actually more suitable in the agricultural district than the urban district. A landfill to many is an unwelcome use, but it is not necessarily an urban use. As a classic NIMBY land use, many do not want to live, work, or play near a landfill. The places we generally live, work, and play in, however, are in the urban district. The urban districts are areas of higher density and closer proximity to other uses and neighbors. The agricultural district is a better location for a landfill because it provides expanses of open space as buffers and away from housing, schools, offices, etc. And in case of fire, flood, or other emergency, there is less potential threat to health and safety than in the denser urban areas. In examining the bases for determining whether a SP or a DBA should be pursued, that is either the 5 guidelines for an unusual and reasonable use, or whether the use simply does not fit in its current district, but fits in another of the 4 districts, one looks at the proposed use, not at the preferred procedural requirements of either the SP or DBA. Even if the procedural requirements were the determining factor for whether a SP or DBA should be pursued, the procedural requirements are not so different or necessarily better or worse than the other. Both provide public notice, opportunity for intervention, and conditions of approval. It is understandably frustrating that these landfill SPs are piecemeal in nature, and perhaps some believe a DBA in one shot can address all the issues that are presented over years and various amendments and hearings back and forth at the LUC and the county through a SP. But a DBA may not be able to remedy the piecemeal nature. The reason that the counties come in for additional amendments for SP landfills is generally because they need 2 things: more time and more capacity or space. And the need for more time and more capacity simply cannot be determined from the outset. Whether it's a SP or a DBA, the advancements in waste management technologies that can provide additional or greater capacity of alternative waste streams or disposal methods that divert waste away from landfills, and the associated policies of alternative landfill siting are most likely going to affect the original closure date or fill capacity of a landfill. I would think the Commission would include in its DBA conditions a closure date in a DBA, just as it would in a SP. So there is the same potential for a county to come back for future DBA amendments, not unlike an SP. Secondly, unlike an amusement park, a landfill is a temporary use with a finite lifespan. Once a landfill is filled to capacity, it can no longer serve as a landfill. A special permit is ideal for a landfill because a special permit requires a reasonable time limit for the establishment and duration of the proposed use pursuant to Hawaii Administrative Rules, Section 1595F. In contrast, a DBA is more appropriate for permanent use of an indefinite lifespan. At the end of the landfill's useful or active life, the landfill is subject to closure requirements pursuant to Subtitle D of the Federal Resource Conservation and Recovery Act, which is adopted under HRS Chapter 342H and implemented by the Department of Health. Subtitle D requires a written closure plan, the installation of a final cover system to minimize infiltration and erosion, which includes a specific permeability and infiltration layer with a minimum of 18 inches of earthen material, and an erosion layer, a minimum of 6 inches of earthen material that is capable of sustaining native plant growth. A minimum 30 years of post-closure care is required, which includes maintaining the integrity and effectiveness of the final cover, maintaining and operating the leachate collection system, groundwater monitoring, and monitoring and operating a gas monitoring system. Following closure of the landfill, the site can be used for other purposes. The future use of a landfill following its closure should not be overlooked, and more importantly, should not be predetermined as limited and necessarily an urban use. The EPA encourages localities to consider closed landfill sites as potential community assets for community uses. While there are challenges to the use of closed landfill sites that include landfill gas and waste settlement, there is opportunity to create treasure out of trash, so to speak. According to the EPA, there are a variety of options for closed landfill sites, including agricultural uses, community parks, nature preserves, structures and buildings, energy generation such as solar, wind, and LFG or landfill gas projects, and landfill reclamation. While perhaps community parks and structures and buildings could be considered urban uses, all of the other listed options are uses generally outside of the urban district. The county's Department of Planning did a great job of listing in their brief the agricultural uses currently permitted under HRS 2052 that could potentially be developed over a closed landfill. So unless it is certain that the future use of a closed landfill will be an urban use, the county should not be limited by a DBA to urban. In this case, the County of Maui is uncertain of what it will develop over the landfill upon its closure. Therefore, it's premature to foreclose the county's options with a DBA reclassifying the land to urban. Lastly, by changing the trajectory of landfills from the SP process to the DBA process, the Commission may effectively be endangering the agricultural district. Under Article 11, Section 3 of the Hawaii State Constitution, the state, including the LUC, has the duty to conserve and protect agricultural lands, promote diversified agriculture, increase agricultural self-sufficiency, and assure the availability of agriculturally suitable lands. By requiring DBA reclassification of landfill areas to urban, the Commission will have eliminated rather than conserved agricultural lands. A special permit temporarily allows the landfill use, but provides that the land should eventually return to agricultural use. Also, a landfill area reclassified as urban could potentially result in spot zoning. That is where you have a spot or puka of urban in a larger agricultural area. The spot zoning would be inconsistent with county general and community plans that strive to keep area uses contiguous and could initiate areas of scattered urban development that intrude on surrounding agricultural areas. Urban classified or zoned areas are often used to justify the urban reclassification or rezoning of neighboring properties, thereby contributing to the growth or sprawl of an urban spot zone. Urban spot zoning could therefore endanger the agricultural district. For these reasons and those provided in our written motion, OP believes that a landfill should be permitted under special permit, not a DBA. Accordingly, OP respectfully requests that condition number 23 be deleted in its entirety. Thank you for your reconsideration.
Thank you, Ms. Apuna. Commissioners, Questions for Ms. Apuna, starting with Commissioner Ohigashi.
I have a question for you, Ms. Opuna. If we do a DBA into urban for this particular parcel, is there anything to prevent the County of Maui from zoning it agriculture?
After the,
I was reading their code, and it says that they have an agricultural zone. So my question is there any prohibition against them zoning it agriculture? And
So
by the way,
once-
I just want to add, by the way, I think this County of Maui zoning code permits landfills specifically as a special permitted use.
so you're asking whether once it's reclassified to urban by a DBA, whether the county can zone it as agriculture?
And issue a SP for the land use landfill portion.
I'm not too familiar with the county. I would defer to the county as far as their zoning, but I think that you could have agricultural uses within the urban district.
And so the other question that I have was that, do you agree that the 40-acre expansion is essentially an industrial park?
No, I actually disagree with that. I mean, I understand that it sounds like industrial uses, but they are basically uses accessory to the landfill. And so they are, symbiotic. You need a landfill in order to have those different facilities and structures, and you wouldn't have them separately. It's like a farm dwelling or other farm accessory uses and structures that come along with the farm.
So you would be disagreeing with the County of Maui. Indicates on page 5 of their memorandum that they filed that requiring the DBA will create a pocket industrial park. So what they're saying is that if we require a DBA, we'll be creating a pocket industrial park. So the county has defined the uses that pocket industrial park. That be correct?
I read that. I think they said industrial, quote unquote, industrial park. And that might be referring
They
back
didn't mean
to,
it.
yeah, they didn't mean it. I think they're referring to
They
what
just
you,
run it for no reason.
no,
Okay,
actually, I think they're referring to what you had characterized it as an industrial park. I believe, Commissioner, that you had characterized it that way and believe those 40 acres were.
I don't see my name in there.
Yeah.
That's why I said that they said it's industrial park. So I curiosity. And would you agree though that the uses that they are proposing normally is in an industrial area?
Yeah, you can find certain structures
Right.
in an industrial zone area.
In fact, like I was reading about there's some kind of use about in vehicles and that would involve in taking them apart or wrecked vehicles. And I was just perusing the County of Maui ordinance, which identifies heavy industrial M2 districts as being the place where such activity should occur.
Yeah, I mean, I think that's possible that you do have those uses could be in industrially zoned areas, but they. Go ahead.
So the use, what I'm trying to get at is, so what you're saying is because it's attached to a landfill, it's not really an industrial use. It's really an appurtenant use. And we shouldn't look at it as what it's actually doing, and try and fit it into a category.
You should look at what it's doing. You should look at how it is connected and it is necessary, or it requires that there be a landfill for those purposes. And it's an entire campus that supports the landfill use. And I think that's different than just being able to separate those two. They're not going to be separated. I mean, they can be in an industrial area if you're going to have maybe a warehouse or something, but these uses are accessory and necessary to the landfill use.
Well, and I appreciate your comment about a theme park and all that, because I guess it refers back to Mr. Okuda's most famous comments regarding neighborhood board versus land use commission. Is that what you're referring to?
Yes.
I do have a quote that I have a hard time getting over from that case, and it's on page 273. And it says that we do not believe that the legislature envisioned that the special use technique be used as a method of circumventing district boundary amendment procedures to allow the ad hoc infusion of major urban uses into agricultural districts. And I just leave that with you because that's, although we have a lot of guidance from the EPA and made those statements, I'm reading this to say that, hey, Supreme Court is telling us, can I have incremental special use permit? We have to devise a system, and the system that we have to review these cases seems to be the DBA's system, especially for landfills. Arguably, it's one thing, but for an area that was designated or requested expansion area or strictly industrial uses, perhaps the procedure is important because it provides additional voting measures, additional person voting. There was people voting against this one. It may not have passed the DBA. It was also requires not only that, but it may require more extensive environmental review given the nature of the industrial use over there. So, that's where I'm getting a hard time making your practicality argument. The law seems
I understand. And I think, when you're talking about the incremental infusion of urban uses with these industrial, accessory uses, at some point when the landfill is closed, the entire campus must close, including those industrial uses. I can't see how the landfill can be closed and those uses can continue. They require a landfill in order to operate. And I think that all of those uses must also close and come down accordingly. So it's not, those uses might be included at some point, but they should be taken down or repurposed if they are going to serve industrial use separate from the landfill. Then there should be maybe a DBA in that case. But as far as purposes where it's connected and accessory to the landfill, it's a complete component.
So your recommendation would be that there'll be a strict finding that upon closure of the landfill premises itself, where we dump the rubbish, that the opportunity uses be closed down and it be reverted back to its original use?
Yes, to agricultural. I mean, I think that's
in other words, we would have to require the county of Maui to reclaim the land, bulldoze everything down.
Either, well, I think they're saying that they only need those uses if there's a landfill. So if you close the landfill, they do not need those uses any longer. However, if they decide that the future use after the closure of the landfill will be some type of industrial use, then they should come in for a DBA. Then they should change the zoning accordingly.
My last question is about who, if we have a DBA and there's substantial compliance, and they built this industrial area, we don't have, the Land Use Commission doesn't have any say, and it's always and it's enforced by the County of Maui itself. In a special permit situation, who enforces that?
Enforces it. I think there's a little bit, and that's a good point you're making. I think that with the special permit, the commission continues to have more of a voice and authority, amendment after amendment, as you did in Waimanalo Gulch, as opposed to, yes, like the DBA, at some point you may be relinquishing your enforcement powers over the special permit. And I know there were issues about how a county applicant can go into a county, planning commission for the decision. So if you take out the land use commission, it's just going to be the county enforcing it. At least the state land use commission can put some checks on these county applications, county permitting.
So who would bring up a violation of the special permit to the commission? Would your office be the one, or would it be the County of Maui?
I think it could be, if there's a recognition of some type of violation, I think it'd be either, depending on what the violation is.
I'm just curious, how does violations work under a special permit for the County of Maui? If the County of Maui is the one monitoring themselves, then that's the answer. If you're telling me that the commission gets to monitor, that's the answer. But we don't have anybody going out there to run around and take a look at what's going on,
And but you have the community too. Okay.
That's my question. I mean, do we have sua sponte enforcement powers to require them to come in and give us a report every month? Go in there. What is our nature of our power under the special permit?
You have the power to require conditions in addition to or different from the county. So if you want status reports.
I'm curious for enforcement purposes. I'm just curious.
I think that if they're in violation of their permit under the, I think that potentially the commission could say, come back in here and tell us why you're violating this and how you will remedy the situation.
I'm sorry to put you in, that was just top of mind. That's why this morning when I woke up, who watches the watchers?
Right.
That's all I have.
Thank you, Commissioner Ohigashi. I think you might have more energy than the rest of us who lived through yesterday. Commissioner Chang.
Thank you, Mr. Chair. Mr. Puna, mine is more of a procedural question. And I may be reading this wrong, but you filed this under 15-15-84. And it says a motion for reconsideration shall be filed with the commission within 7 calendar days after the issuance. And then section 84C says, in no event will the commission consider any motion for reconsideration on any petition after the period within which the commission is required to act. So I'm trying to understand, is this motion for reconsideration even, should we even be considering it? Because it appears to be untimely.
Thank you. Yes, Commissioner. And OP apologizes for the late filing of this motion. Part of it was once we got the decision order, then we needed to get the transcripts, and we went through it, and there was some we had some discussions with the staff trying to understand what was happening here, and it did take some time to file that motion, which we apologize for. As far as the
No, but do we have any discretion? Because it says in no event. So it appears as if you know, even though I know you're apologetic, but I'm looking at C and reading it that we have no discretion. If it's filed late, we cannot consider it. And I'm sorry, Mr. Okuda probably has read the case law in this area. It is probably much more akamai than I am because I don't have the case law, but I read this as we do not have discretion.
I know it says in no event, but I know that there is a rule that allows for a change in what the rules require if there's good cause or if it's reasonable to allow a change in the rules. And as far as within which the commission is required to act on the petition, I'm not sure if that necessarily, that period, I need to think about that because I think I did read this and I came up with a different conclusion, but that.
Well, I'm going to let Commissioner Okuda, because I suspect, like I said, he's probably got the case law behind this. But the other question I have is, I understand your argument about what was the intent of the commission. Was it 22 or was it the 90? That to me is perhaps, maybe it's erroneous. So that seems to fit under one of the reasons for reconsideration. But the discussion whether a DBA is appropriate or not, wasn't the opportunity to raise that? And my recollection is that was discussed at the hearing. So it doesn't appear to be an appropriate grounds for the reconsideration to reopen the discussion on whether the DBA or the SUP is appropriate.
Yeah, I understand that. We did make arguments, the parties did make arguments. I personally feel that OP could have presented more information on that argument because at the hearing is when we realized that it was a very important, obviously a very important issue to the commission because it became a condition itself. But I think that if anything, if we're not able to delete condition 23, I think we just wanted to reiterate what we believe is the direction that we think the commission should understand or at least consider when other landfills come before you. That this is an important issue that we really don't want to see this to be a trend for landfills.
And my recollection is when we did the Waimanalo Gulch, this was an issue that came up and the commission raised the same issue, the same arguments. So I know it's not a new position. I mean, if there's a trend, the trend is probably to require a DBA rather than an SUP. So let me just ask you one factual question. Are you aware of any landfills in Hawaii that the zoning is ag, but they have an SUP that after the end of the landfill, it's reconverted back to ag?
I'm sorry, I don't have that information with me right now.
Because it does not, I'm not aware of any landfill that's gone back to ag use. So I understand your argument, it's a temporary use, but factually, they don't appear to be going back to ag use. So in my view, your argument about it being, it could revert back, that's not consistent, at least with what's the status in Hawaii. So those are my issues that I'm having, the trouble that I'm having with the motion for reconsideration. it's a legal question as well as what's appropriate. So with that, Mr. Chair, I don't have any other questions, but like I said, I'm sure Mr. Okuda, Commissioner Okuda has more legal authority than I do.
Commissioner, can I just respond shortly to
yes,
Commissioner Chang? As far as there being, in Hawaii, landfill sites that have closed and have reverted to, I can't speak to that, but understanding what the EPA has said since maybe 2014 and them promoting uses after the closure of landfills, including agricultural uses, it seems to be a trend on the mainland. There were in 1984 something like 8,000 landfills, and now there's 3,000. So many of them, a good proportion of them, are being reused. And this behind me is a solar farm that was in Vermont that was built over a closed landfill. So maybe it's not happening here yet, but it seems to be a trend on the mainland to repurpose landfills that have closed.
Yeah, and I think my comment to that is, I would suspect on the continent where maybe landfills are, there's a lot more land. And so now with urbanization, I mean, Maui's been a little different than Waimanalo Gulch. We have not had the public opposition. But one of the rationales used by the counties, it's a temporary use. But then we have them coming back in for an extension. So for the communities, there's an expectation it's temporary, but the inconvenience, the damage, the adverse impact lasts a lot longer. So the realities in Hawaii, in my view, are a little different than what may be occurring on the mainland. I'm hoping so, but I don't know how analogous that is to Hawaii. All right, thank you.
Thank you.
Thank you, Commissioner Chang. Commissioner Giovanni, followed by Commissioners Okuda and Wong.
Thank you, Chair. I will defer to Commissioner Okuda if he'd like to follow up on Commissioner Chang's inquiry, if that makes sense.
Commissioner Okuda, did you want to, I don't know where your questioning was going, but I think you are being asked to share your thoughts regarding the timeliness of the filing of the motion.
Yes, and it'll be short, and I'll defer back to Commissioner Giovanni. No, I don't have any case law. I'm sorry to disappoint Commissioner Chang. And if I did, remember the old saying, my legal advice is worth exactly how much you pay for it, which is nothing. But on that line, I not knowing what the answer is, and maybe this is something that we have to look at down the road. But Ms. Apuna, isn't it true that certain types of time deadlines are just absolute? For example, notices of appeal, it's an absolute deadline. The statute of limitations, unless you have some equitable tolling reasons, that's an absolute deadline. But there are other types of deadlines where there may be discretion to extend the deadline. I mean, is that a fair statement of the two different types of deadlines? I mean, some deadlines are drop dead deadlines and other deadlines might not be drop dead.
Yes, I think that's correct.
Okay, but do you know of any authority, because I haven't tried to look it up, by the way, do you know of any authority which indicates whether or not the language, because I do agree with Commissioner Chang, that language seems pretty definitive, whether or not the language in the administrative rule is a drop dead deadline, or whether it's the other type of deadline where there might be discretion to extend the deadline?
Well, I would hope there'd be discretion to extend the deadline, particularly in this case because it's a matter of 22 acres versus 95 acres, and that's a huge amount of land of the county, to have to convert or change. It's so just clarity seems to weigh in being able to find out what was intended by the by the commission.
Okay, and let me say this. I think you've changed my thinking on some of the things. I came into this hearing being dead set that, if it looks like the old cliche, if it looks like a duck, quacks like a duck, it's got to be in an urban zone. And I've listened to your argument about spot zoning, about how the requirements of the Hawaii Constitution have to be taken into account. And my own personal view is I think you've made a pretty good argument where I've got to reconsider what I was thinking before. But can I ask you this? Would you agree that there may be certain types of landfill situations or requests where the appropriate response by the Land Use Commission is to make a ruling that the applicant must go by way of boundary amendment and not special permit, but there might be other landfill situations where it would be not appropriate to go by boundary amendment? It's a case-by-case basis.
It is, but I think we're concerned that that the commission is directing everything towards a district boundary amendment. But you are correct. I think even when it is currently under a SP and it just seems that it must that there's no end and it will continue to be urban even after the closure of the landfill, then yes, perhaps a DBA should be required in that situation. But generally speaking, for landfills, we should continue to keep it in the agricultural district and hopefully be able to return it to agricultural or some use other than urban, so as not to take away land from the agricultural district.
And final question, and if you believe that you don't have enough information at this point in time because the question is speculative, then that's okay if you tell me that. But what is your view if, for example, the adjoining landfill is closed, but the county were to open a landfill at some other location and say that the facilities that were built now should remain because these facilities are still going to be used, but accessory to a landfill located somewhere else in the county of Maui?
Now that's very interesting. That's an interesting question because I see that there is still the connection with the landfill and accessory use, but they are now spatially separate. So maybe it could go under industrial or urban use, those uses, but I don't know. Yeah, I would need more information and be able to look at that.
Okay, thank you very much, Ms. Opuna. Thank you, Mr. Chair. I'm sorry, I'm not prepared to answer Commissioner Chang's question.
Okay, thank you, Commissioner Okuda. Commissioner Giovanni, followed by Commissioner Wong.
Thank you, Chair, and thank you, Ms. Opuna. First of all, I want to thank Commissioner Ohigashi and Commissioner Chang and Commissioner Okuda because I heartily agree with their line of questioning and the positions that they imply or that I have felt that they represent. Now I'll go on to my own line of questioning. Ms. Opuna, looking back at the record on this case, if you recall, in our questioning of the of Maui, in our question of Maui County, there was reference to a solid waste management plan, but there was no plan that was made as part of the record specifically. So we had to go on representations that were generally made that called out a reference to that plan, but we never got to see the plan itself. Do you recall that discussion at all?
I think I do, yes.
So along those lines of questioning, one of the questions that I asked was, is the industrial activity that would be on the 40 acres that is envisioned by Maui County, does it have to be connected or co-located next to the landfill? because similar technology, like for example, on Oahu, you have H-Power, which is several miles away from the landfill. And in essence, it's processing waste in an industrial way. And then the residual from that industrial activity is trucked miles to the landfill. You recall that line of questioning?
Yes, I do.
And they specifically said that it does not need to be connected. In fact, it's a matter of convenience or of optimal design. You recall that?
Yes.
So I think that is in direct conflict with your testimony today, which represented that the industrial activities that would be envisioned, and I very much see these as industrial activities on the new 40 acres, are not symbiotic in terms of spatial connection to the landfill itself. They could be located anywhere on Maui, and the residual products from those industrial activities could be trucked to this existing landfill. So I think that's in conflict with what your position was. Would you still be in conflict with that, with what I'm saying, and hold to your position, or would you go back to what was on the record from Maui County?
So I can't speak for the county. I think what we're looking at as far as the discussion, or what I think OP has looked at for today's discussion, is where it is located, adjacent to, industrial uses are located adjacent to the landfill. So I haven't given much thought to that. I think that's a good question as far as the spatial separation. So I don't really think I have an answer for you at this time on that, but I will take note of it and discuss with OP.
Okay, thank you for that. But I want the record to show that in my mind, I go back to what's on the record, and it's spatially located there as a matter of convenience and perhaps optimal design and efficiency, but it's not a required technological requirement to be collated adjacent to a landfill. I also agree with Commissioner Ohigashi that it's very much industrialized activity, and it's clear that the way that solid waste management is evolving in this day and age is more to the direction of diversion and processing of waste, where you separate waste streams. You take each of the separated waste streams, for example, plastic, metals, whatever, and you process those individually and try to make reusable products of those, so that what actually ends up as a residual and goes into a landfill is a much smaller volume. Would you agree that that's a fair characterization of the evolution of the technology that's going forward?
Yes.
It is. So that really means that, and the reason I emphasize that is that under the moniker of a landfill, oftentimes these industrial processes are mischaracterized as a landfill requirement or as a landfill activity, and they are not. They are specific industrialized processes that could be located anywhere on this island, on any island, for purposes of separating, sorting, and processing waste for reuse. It's only unfortunately that in the event that you can't recycle 100% and you end up with a residual product, and then it's that residual product that ends up in a landfill. Does that make sense to you?
Yes.
So as a consequence of that, landfills that were designed and envisioned in these solid waste management plans 5, 10, 20 years ago by counties were much larger and much more difficult to cite because they took a multitude of waste and a much higher volume of waste. So fortunately today, landfills on islands are hopefully a little more easier to locate because they don't need to be as big and they don't need to take so much of the waste. So that's what's going on. So recognizing all of that, I go back to what your motion is. I think very clearly, and I'll take the two parts. I, for one, hope that we could take your motion under consideration to clarify the 22 versus the 95 acres. Because I do think that the intent was, at least my personal intent in support of the order at the time, was that it be for the entire parcel. Because I see it as an industrial activity, and I see that's the choice that Maui's making, because they don't need to put that industrial activity there, but they're choosing to do it. And as difficult as it is, even on islands, to get these technologies cited and these operations cited, I think it's highly speculative to say that it's temporary. I think they're pretty much, in my view, semi-permanent, and it's more appropriate to be recognized as a semi-permanent or permanent industrial use, and it's well suited to be in the urban district. And that's why I support that we do not alter the condition number 23 for this order. Does that make sense to you? My position.
It does, but I would ask if you do, you strongly believe that the accessory industrial uses should be urbanized, then why not just limit that DBA to those industrial uses, but allow the landfill itself to continue an ag for the potential of possibly returning it back to an agricultural use?
I would consider that. My problem is that I think that, again, in the absence of having access to the solid waste management plan, which I think is going to be an evolving thing, I'm trying to look out for the county. I think that if the county had a DBA for urban use for the entire parcel of 95 acres, it will probably, 20, 30, 40 years from now, there might be a whole new host of technologies that come into play, and they might want to repurpose that whole land in an industrial basis. They may want to put industrial things on top of the existing landfill. I think that if the whole parcel is categorized as urban, it gives the county a lot more flexibility to do what's in the best interest of the people in terms of solid waste management on a long-term view basis. That's why I would support it. I think the notion of a landfill in the context of the 1960s or 1970s just doesn't fit into to today's perspective of how landfills fit into the mix for solid waste management on islands.
Right. I see that. I just worry that if we urbanize this area, that there is a potential for the outer lying areas or the adjacent areas to also therefore be urbanized, because once you have urban, people are going to justify further urbanization based on that one spot. And
very valid point, and I will take that into consideration. So thank you for making that point. I don't have anything further.
Thank you, Commissioner Giovanni. Just immediately prior to calling on Commissioner Wong, Ms. Apuna, I'd like you to confirm at some point today where the nearest urban parcel is to this area. Commissioner Wong.
Yes, Chair, thank you. I'm going back to Commissioner Chang's line of questioning to the OP. I would like to make a motion for executive session regarding our duties, responsibilities, meeting with our Attorney General and staff about this issue, validating the reality of the timeliness of this motion.
Second the motion, Mr. Chair. This is Commissioner Axon.
Okay, a motion has been made by Commissioner Wong and seconded by Commissioner Axon with a near third by Commissioner Ohigashi. If we go into executive session, Mr. Ordinko will send out a separate meeting room notice. You will log out of this meeting room, go into that other meeting room, and then we will come back into this meeting room when we're done with executive session, if the motion prevails. Is there any discussion on the motion? Seeing none, Mr. Ordinger, will you please, oh, Mr. Hopper? You are muted.
Don't know if you want to hear it all from the parties on that particular issue. I did have a reading of the rule that I wanted to send forward. If you just want to go to executive session, that's fine, but
I think the request was, I'm gonna assume at this point that Commissioner Wong knew that we might hear from the other parties after executive session, but thank you for the offer.
Okay.
We are in discussion on the motion. Is there any discussion? If not, Mr. Ordinger, will you please roll call the commission on the motion to go into executive session?
Thank you, Mr. Chair. Commissioner Wong.
Aye. So I was drinking coffee.
Of course.
Commissioner Giovanni.
Aye.
Commissioner Ohigashi.
Aye.
Commissioner Okuda.
Yes.
Commissioner Cabral.
Yes.
Commissioner Chang.
Yes.
Commissioner Axon.
Aye.
Chair Scheuer.
Aye.
Unanimous, Mr. Chair.
Okay, thank you. The commission will move into executive session right now into a separate Zoom meeting room. This Zoom meeting room will remain open and akin to the physical world. You'll kind of have to cool your heels while we are in executive session, and then we will come back into this when we're ready. Commissioner Ohigashi.
We can stay logged on to this one.
No, you log out of this one.
We leave.
You log out of this one, log into the link that will be sent or has been sent by Commissioner or by Executive Officer Ordinger.
Thank you.
Thank you. It's 11:04. We're back on the record. Thank you for everyone's patience. I'm just going to note to start us back, we were procedurally questioning the OP after their presentation on their motion, and an issue was raised and subsequently discussed, raised by Commissioner Chang and subsequently discussed by many of the commissioners over the applicability of Hawaii Administrative Rule 15.15.84 regarding the timeliness of filing motions for consideration. Mr. Ordinger, would you like to speak to this rule? You're muted.
Thank you, Mr. Chair. As Commissioner Chang pointed out, the time for filing a motion for reconsideration has passed. It does not appear to be discretionary. 15.15.80, I believe it's 89, provides that the motion for reconsideration
84.
So we filed in a timely manner, and that if it is not, then the commission may not take up the matter. The motion for reconsideration was actually filed with, from OP, was filed with two issues. The primary one that the staff recognized was the error that staff had made with regard to the condition requiring the county to institute DBA proceedings, district boundary amendment proceedings on the landfill. Staff had mistakenly believed that the motion was to cover only the additional acreage rather than the entire acreage of the landfill. And in that regard, it was staff's opinion that the motion for reconsideration was actually a motion for clarification. With regard to the second item that OP raised, or the second issue that OP raised with regard to whether or not the condition was appropriate at all, that is clearly a motion for reconsideration and fell outside of the commission's jurisdiction, given the date on which the memo was filed.
Thank you, Mr. Ordenker. As chair, I would entertain a motion that based on 1515-84, we should stop consideration of the motion because it was filed untimely. I will note that if such a motion is made and prevails, I would direct the staff to put on our next agenda a clarification of what was meant by our previous order in this case. Commissioner Higashi.
I move.
Is there a second? Seconded by Commissioner Chang. A motion has been made by Commissioner Higashi and seconded by Commissioner Chang to cease consideration of the motion by OP because it was untimely. Commissioner Okuda, or Higashi followed by Okuda.
No comments, John. No comments, Mr. Chair.
Okay, Commissioner Okuda.
Thank you very much, Mr. Chair. The reason why I'm speaking in favor of the motion is it doesn't mean any disrespect to any of the parties, especially to the Office of Planning, which I believe has raised very important and items that I really need to think of in the future. But the motion that has been filed implicates the rule which Commissioner Chang raised, and that rule seems, in my view, related to whether or not the time for appeal can be tolled. And these types of tolling motions, especially when it's related to when a deadline is to file a notice of appeal, it becomes an issue of subject matter jurisdiction. And so when it's a subject matter jurisdiction type of rule, time limit rule, and if that time passes, then even if we think it's a really, really good idea to do something, if we don't have subject matter jurisdiction, as we all know, we can't proceed. And in fact, if there's a lack of subject matter jurisdiction, even if we were to proceed, a court later, like an appellate court, can on its own sua sponte raise the lack of subject matter jurisdiction. So that's basically the reason why I'm speaking in favor of the motion. It's no reflection on the substantive arguments that the Office of Planning was raising, but in this format right now, I believe the motion is not only untimely, but there is no discretionary ability to extend a type of tolling motion when it may toll the deadline to file a notice of appeal. Thank you, Mr. Chair.
Commissioner Chang.
Thank you, Mr. Chair. Yeah, I too am obviously going to vote in favor of the motion. And I see this as a procedural matter. It is nothing to do with the merits of the arguments. Although one, I think that there are appropriate remedies to address the issues that have been raised by the Office of Planning. One, as I understand from Mr. Ordenker, staff is going to, there may have been an error on the part of staff in the acreage. And that seems like we're going to take that up at the next meeting, and staff will come forward with that matter, and it will be properly agendized. I think the other issues that OP is raising, like Commissioner Okuda, while they may have merit, one, I think that those were raised in the original hearing, and two, that issue can always be brought up in another, a more appropriate motion before the Planning Commission and then ultimately to the Land Use Commission. So for those reasons, I'm going to vote in favor of this motion. Thank you.
Okay, I'm going to, we're in debate on a motion before the commission. So normally just the commissioners would vote, but I'm going to briefly recognize Mr. Hopper, then followed by Environmental Management.
Thank you, Mr. Chair, and thanks for letting me speak. I understand you're in deliberations. I just wanted, for our own purposes, some clarification. The rule does say that a motion for reconsideration has to be brought within 7 calendar days after the issuance of the DNO. And then it says, in no event will the commission consider any motion for reconsideration on any petition after the period within which the commission is required to act on the petition. And I wasn't clear on what that time frame is, the period upon which you're required to act on the petition. I think my reading is that you have 45 days after receipt of the full record under 1515-96A. I would have thought that period, I don't know if you made your original decision within that period or not. I had kind of assumed that that time frame was told based on the governor's proclamation, because we know that there was a COVID delay for hearing this petition, but we would want that clarification as to, it doesn't say that you can't consider beyond the 7-day time frame. It says that you can't reconsider after the period in which the commission is required to act on the petition. So that clarification, I think, would help. Also, if it's a jurisdictional issue and the time frame for appeal is the issue, then I'm not sure how you could make a clarification to your DNO beyond that period. If that, I don't see how that's different. So just some clarification. If you can't give it or don't believe it's appropriate now, then that's up to you. But we would, I think, also want to raise this as an objection based on those issues without having those items clarified, because in reading the rules, those were a couple of the questions that I had, and you may have addressed them in executive session with your AG, but I just did not have that information.
I don't think any of us are going to speak to what we discussed with our AG in executive session.
Of course not.
Environmental management.
Thank you for the opportunity. Just briefly, wanted to, Michael Hopper and I were in separate rooms, so we didn't have the opportunity to talk in depth about this. But you know, we do agree with him and would like the commission's clarification on that. An alternative, perhaps an alternative way of viewing this petition would be a petition to modify a condition or delete a condition under 1515-94, which may address some of the timeliness issue. So I don't know if the commission would consider OP's petition in the alternative as being brought under 1515-94.
So I think 1515-96.1, if I have that correctly at my grasp, is the vehicle for a motion for modification of a special permit condition. Counselor, do I have that correct?
That is correct.
So, you know, there's nothing about the motion that is before the Land Use Commission today that prevents the county from appealing the original decision that we made. There's nothing that prevents you from going through under 1515-96.1 through your planning commission and then bringing a motion to try and remove the condition which you find objectionable. But that's not what OP filed. Ms. Apuna.
Thank you, Chair. I'm wondering if OP can make a motion at this moment under 1515-70 to modify or to amend the special permit.
Under 1515-70.
Yes, I think it allows a verbal motion by any party during the hearing.
So one of the issues that will arise, I don't think that it's allowed, is because this is actually the consideration of a special permit in which there's not technically opposing parties involved. So I'm not sure that 1515-70 applies in this instance.
Well, we're a party to this motion, so.
But there's nothing also that would prevent you from refiling and recharacterizing. How did you say that you wanted to recharacterize your motion?
To a motion to modify or amend.
Okay, so then I believe that as I said before, 96.1 would be the appropriate administrative rule, which covers motions to amend conditions on a special permit, which would originate with the Planning Commission. But this actually goes more towards the second point of your arguments, which you presented, which I want to refer to as the Funakoshi arguments, that somehow this should not be allowed at all, rather than whether or not the decision and order properly reflected what the commission decided. Commissioner Chang.
Mr. Puna, I too thought maybe we could make an oral motion, but I think the issue, the legal problem that we may have is just sunshine. So I think that's why, looking at this, it seemed to be the most appropriate vehicle is that staff, they've acknowledged the acreage issue may not accurately reflect what the LUC's decision was. So they'll agenda that at the next meeting. But I think that that's the problem with making a motion orally without properly providing sunshine notice for it.
Commissioner Axon.
Mr. Chair, I believe we have a motion on the floor.
We do have a motion on the floor.
And if there's any motion, if any, should be taken after this motion.
Yes, I just want to sort of err on the side of not having any of the two county agencies or OP feel that they were excluded from any, an opportunity to speak to this when they were raising their hand. We do have a motion in front of us, and if I may speak to it, I believe there's gratitude that the difference between the conversation that was had during the hearing and then the DNO was brought up. And that's why I do want to direct the executive officer to place this on the next agenda for attention, but to do so in a way that we believe is appropriate under our rules. Is there any further discussion on the motion? If not, Mr. Ordenko, will you please poll the commission?
Thank you, Mr. Chair. The motion is to dismiss this matter for lack of jurisdiction as it was untimely. Commissioner Ohigashi.
Aye.
Commissioner Chang.
Aye.
Commissioner Axon.
Yes.
Commissioner Cabral.
Yes.
Commissioner Giovanni.
Aye.
Commissioner Okuda.
Yes.
Commissioner Wong.
Aye.
Commissioner Scheuer.
Aye.
Thank you, Mr. Chair. The motion passes unanimously.
Okay, so just to be really clear, Mr. Ordenko, I'd like you to place the clarification needed regarding the decision and order onto our next agenda.
Thank you, Mr. Chair. Thank you, Mr. Chair. We will do so.
And obviously keep in touch with the interested parties as is appropriate and necessary. There being no further business to conduct, unless anybody has something else, I'm going to declare this meeting adjourned. Thank you, everyone.